Welcome once again to Lehto's Law. Here's Steve Lehto.
I've talked before about attorneys using AI, and I most recently did a video about the excuses attorneys had used, and I said, at this point, I can't imagine what's going to come along that'll make me want to talk more about lawyers using AI, because I think I've covered it all. And just when I think I've covered it all, along comes this, and a lot of people send it, thank you very much, but we now have an example of an attorney who got caught using AI, who was called before the court to explain his use of AI, and in response to that request, filed more stuff containing more AI. And of course, the court caught it and called him out on it. And so now we have this. And I've got the opinion in my hand. It's a 5-page opinion when I printed it out. I removed a bunch of extraneous material. I think the opinion is actually 9 pages long. The opinion is called Atty versus Atty, A-D-E-R, Atty versus Atty. It's out of a Supreme Court of New York County, New York. But remember that in New York, the Supreme Courts are the lower courts. The higher courts are called something else, just to keep us on our toes. This opinion was handed down this month, just a few days ago. And this case adds another unfortunate chapter to the story of AI misuse in the legal profession. Here, defense counsel not only included an AI hallucinated citation and quotations in the brief that led to the filing of this motion for sanctions, but also included multiple new AI hallucinated citations and quotations in their brief opposing this motion. In other words, and here's the summary. In other words, counsel relied upon unvetted AI to defend his use of unvetted AI. Now, buried inside that sentence was a subclause that says, in his telling, it's because of inadequately supervised colleagues. But the question, of course, then is, well, who ain't supervising them? Oh, wouldn't that be your job? And again, if you sign the documents, it becomes your responsibility. So the plaintiff in this case was the executor of an estate of her late husband. She is seeking sanctions against defendants. One is a property holdings company, and the other defendant is her son, believe it or not. That's why it's Atty versus Atty. But also as well as defendant's counsel. For the reasons discussed below, and as stated on the record after they had oral argument back in September, plaintiff's motion is granted. That is, the sanctions will be issued. The factual background of this case is probably not important. It's an estate. But here, plaintiff contends that defendants made several misrepresentations in their brief opposing a motion for summary judgment, including that defendants had diligently pursued discovery when in fact they had not made a single discovery request in the action, and that plaintiff violated a court order in a matrimonial case. The court discussed these issues in a previous decision and finds that the only representation regarding discovery requests constituted a misrepresentation of fact. So a summary judgment motion, it's often called different things in different states. In Michigan, it's summary disposition in our state courts, is when you go before a court and says nothing to try, here is no triable issues of fact, for instance, the court can simply rule now. There's other bases for summary judgment motions, but a summary judgment motion, in essence, is asking the court to make a ruling that will probably dispose of a major portion of what you're fighting about in a case. So, more significantly here, plaintiff identified inaccurate citations and quotations in defendant's opposition brief that appeared to be hallucinated by an AI tool. After plaintiff brought this issue to the court's attention, defendants submitted a surreply affirmation in which their counsel, without admitting or denying the use of AI, acknowledged that several passages were inadvertently enclosed in quotation and clarified that these passages were intended as paraphrases or summarized statements of legal principles established in cited authorities. Plaintiff then submitted a letter in rebuttal to the surreply affirmation, to which the court invited defendants to respond, and defendants then responded. As set forth in detail in that letter and papers in support of the instant motion, defense counsel's explanation of the citation and quotation errors as innocuous paraphrases of accurate legal principles does not hold water. Among other things, the purported paraphrases included bracketed terms to indicate departure from a quotation, which is something you would not expect to see in an intended paraphrase, and comments such as citation omitted. Moreover, the cited cases often did not stand for the propositions quoted, were completely unrelated in subject matter, and in one instance, did not exist at all. Even as to the subset of fake quotations that happened to be arguably correct statements of law, the court rejects the invitation to consider that actual authorities stand for the proposition that bogus authorities were offered to support. Use of fake citations and quotations that may generally support real statements of law is no less frivolous. Indeed, when a fake case is used to support an uncontroversial statement of law, opposing counsel and courts in many instances would have no reason to doubt that the case exists. The proliferation of unvetted AI thus creates the risk that a fake citation may make its way into a judicial decision, forcing courts to expend their limited time and resources to avoid such a result. Unfortunately, the summary judgment briefing is not the end of this troubling conduct. Despite previously assuring the court in defense counsel's surreply affirmation during the summary judgment briefing that every effort will be made to avoid the recurrence of such issues and to maintain the clarity and integrity of the submissions before this court, defendants' opposition to the sanctions motion contains another wave of fake citations and quotations. This time, plaintiff has identified more than double the number of miscites, including 4 citations that do not exist, 7 quotations that do not exist in the cited cases, and 3 that do not support the propositions for which they are offered. Separately, although not the subject of this motion, plaintiff has also alerted the court of still more fake citations in defendant's opposition to plaintiff's application seeking attorney's fees in connection with the award of summary judgment. In response to the overwhelming evidence skillfully marshaled by plaintiff's counsel in the instant motion, defendants vehemently denied the use of unvetted AI and complained that plaintiff provides no affidavit, forensic analysis, or admission from defendants confirming the use of generative AI, thus implicitly suggesting that AI was not used in preparing defendant's summary judgment brief. At oral argument, the court gave defense counsel the opportunity to set the record straight as to how exactly the many citation and quotation errors found their way into the briefs in this action. Defendant's counsel began with a prepared statement in which he acknowledged some citation errors, but continued initially to maintain that the cases are not fabricated at all. Ultimately, upon questioning by the court as to how a non-existent citation could possibly end up in the briefing without the use of AI, counsel conceded that he did use AI, contending that he did verify and check the AI, but must have missed the false citation, which he conceded for the first time was an AI hallucination. With respect to incorrect quotations from actual cases, counsel acknowledged again for the first time under court questioning that they were not his own drafted paraphrases from the decisions, but were instead AI-generated fake quotations that were not properly verified. And so the court goes on for several more pages pointing out how apparently the attorney had stuck to his guns and said, nope, that's not AI. Then said, okay, it might be AI. Okay, it is AI. Okay, it was my paralegal's fault or somebody I'm supposed to be supervising. It's their fault. And of course, if you're supposed to be supervising them, then it's your fault. It just is. But if you sign the documents, again, it's your responsibility. And I've said that before. Understand that when an attorney files a pleading with the court and they sign it, the person who signs it, the signatory, is on the hook for that document. And generally, it's not a big deal because I draft a document, I sign it, I stand behind what I write. And I've had occasion where somebody helped me write something, and I read it very carefully. If I'm going to sign it, you better believe I read it very carefully. Of course I do. So at the very, very end, it says, therefore, it is ordered that plaintiff's motion for sanctions is granted. such that defendants and their counsel are jointly and severally liable to compensate plaintiff for reasonable costs and attorney fees incurred in connection with this motion, together with fees and costs attributable to addressing defendants' unvetted AI citations and quotations in the summary judgment motion. Is further ordered that plaintiff shall submit an application with supporting documentation for the fees awarded above within 14 days. Defendants and their counsel may submit opposition thereto within 14 days of that. Plaintiff shall notify the court via letter filing on NYSCEF and by email when the application is complete and whether it is opposed or unopposed. And it is further ordered, and here's where it gets interesting, that plaintiff's counsel promptly submit a copy of this decision and order to the Grievance Committee for the Appellate Division, 1st Department, in the New Jersey Office of Attorney Ethics, copying defense counsel and this court on its transmittal letters. And so the attorney who did this is going to get sanctioned, probably have to pay attorney fees and costs to the other side for having it happen, and had to notify the people who are in charge of licensure to see if they want to take any action regarding their ability to practice law. And so the amazing thing here is, and I understand that everybody in the audience understands this. Everybody understands this. But somehow the attorney didn't. And one of the people who sent me a note about this said, Steve, can you believe that an attorney actually did this? And another friend of mine who sent this to me, I wrote back one word, I said, unbelievable. And my friend wrote me back and he goes, strangely, I find it believable. And I said, yeah. I'm not using the word literally. You'd think if you got caught doing something, in explaining why you shouldn't be punished so badly for what you got caught doing, that you wouldn't do it again in that explanation. So some people don't see the irony of what they're doing. And how this could happen, I don't know. But it happened. And what appears, and I'm reading between the lines on this 9-page opinion, what appears to have really upset the court is that there's motions and briefs filed. And the court's reading through them, and I believe one side said, hey, there's some stuff that's made up in their brief. And it gets called to court's attention. And instead of just saying, I did it, can I refile the brief without that? And, I'll take my lumps on this. Instead of doing that, they doubled down and wouldn't even admit what had happened. So then the court says, how about this? Let's have a hearing on sanctions. Sanctions. Attorneys don't want to hear that. An attorney knows that could cost him money and possibly get him in trouble with the bar. So let's have a hearing on sanctions. So brief the issue of sanctions. The one side says, we're entitled to sanctions because they filed this brief with this stuff. We had to go through with a fine-tooth comb and discover these things. We wasted a bunch of time and money. And the other side says, did nothing wrong, and here are the case law, and here are the cases that prove it. And guess what? AI found them a bunch of cases that said what they did wasn't wrong. The cases were made up. I mean, I hate to say you can't make this stuff up because it's a cliche, but seriously? And again, if you get caught doing something red-handed, as they say, you get caught doing it. Do you do it again while you're trying to explain how you didn't do it the first time? I mean, that's just so far beyond. And so I don't know anything about the attorneys in this case. In fact, the attorneys' names aren't even mentioned in the case. And to me, the attorneys' names aren't important because I wouldn't know who they were anyways. I don't practice law in New York. And this is happening in New York. I did catch a reference to New Jersey, which makes me wonder if a person might be licensed in both jurisdictions. But really? And don't get me wrong. I know a lot of attorneys out there who are working really, really hard, putting in really, really long days. I've heard attorneys say they work 80, 90 hours a week. It's possible. But you understand that there are certain corners you cannot cut. And I've heard of attorneys who have cut corners by doing things that were completely wrong. So I'll just make up an example. Let's suppose I had to file a brief and I realized I needed an affidavit from a witness. And I can't reach that witness. But I know what they testify to. Boy, it'd be nice if I had an affidavit that somebody had written up that witness had signed saying, here's what I'll testify to. Guess what? I can't submit the affidavit to the court and say it was signed by a witness if it wasn't. But it would save some time. Doesn't matter. I'm overworked. Doesn't matter. And I've mentioned before that you're on the hook for stuff you sign to the court. There's also a duty you have to the court. And one of the duties that they say you have to the court is a duty of candor. Candor, C-A-N-D-O-R, candor. And candor with the court is talking about being honest and respectful to the court, speaking truthfully. So the court asks you a question, you give them an answer that's correct. And you deal with the court in good faith. And so if I submit something to the court that I've signed, as mentioned before, my signature means I'm verifying that I read it, it's accurate, it's truthful, it's being filed for a proper purpose. Presumably there's not made up stuff in there. So there's a breach of duty, a breach of the duty of candor with the court by doing that. And by the way, I'm not familiar with the rules of ethics of New York or New Jersey, but I have a sneaky feeling they've got rules that say both. You sign it, it's on you. And you have a duty of candor to the court. So the first time you do it and you get caught, that should be a learning experience. When you do it a second time and get caught, especially when the second time relates to the first time, I don't know what I would do if I was the judge. I'd want to go nuts the first time. But how do you escalate going nuts? I don't know. I don't know. So we don't know yet what the sanctions might be in a case like this. When we find out, I'll let you know. But what we have here, again, just to make sure it's clear, counsel relied upon unvetted AI to defend his use of unvetted AI. It was an attorney in the same case, caught both times. Unbelievable. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. Sarcasm is just another service I offer.